Ladies and gentlemen, we have gathered here for a workshop on the Digital Personal Data Protection Act 2023 awareness. Let's welcome our speaker, Mr. Priyanshu, domain expert, cybersecurity. Let's put your hands together for our speaker.
Hello everyone. I hope you all had your lunch, right? Okay, so let me introduce me first. I am Priyanshu. I'm currently in NEGD, Ministry of IT, Information Technology, and currently I'm handling all the awareness of the DPDP Act, and I organize various. We organize in the NEGD various workshops on DPDP Act. So. As you know, there's a lot of heat around DPDP Act, right? This is a change. So in this session, we'll be covering personal data protection, the legislative landscape of the country. Right, thank you. DPDP एक्ट के अलावा और क्या क्या legislations हैं जो कि जो have provisions to protect personal data, existing provisions in Indian laws, DPDP Act के principles, applicability, rights and duties of principal, obligations of data fiduciaries, data protection boards, and we'll see the structure of the rules also. Although we won't discuss the rules here because we are awaiting the rules. It should be enacted right now, but it is delayed little further. So आप लोगों को history तो basic पता ही होगा कि from the 2017 there is expert committee formed under Justice retired B.N. Sri Krishna. Then we have a Justice Puttaswamy case in 2017 which जिन्होंने बोला कि right to privacy is under the constitutional right, Article 21. फिर पर्सनल डेटा प्रोटेक्शन बिल आया 2019 में विच इज़ अगेन विड्रॉन इन 2022 एंड वी हैव द डिजिटल पर्सनल डेटा प्रोटेक्शन एक्ट 23 विच वाज इंट्रोड्यूस्ड इन 22 एंड गॉट एसेंट इन 23, राइट. So these are the already provisions under various acts and constitutions which require the organizations to protect personal data of the citizens. IT Act under Section 72 provides punishment under penalty in case of breach of confidentiality and privacy of electronic records. We have Section 43A which provides penalty to body corporate mismanaging sensitive personal data. And this is why we need the DPDP Act, because under IT Act it only covers the sensitive personal data. We didn't talk about the the normal personal data, and the DPDP Act will replace the Section 43A Act of the IT Act. Then we have various secure under the Aadhaar Act also. It deals with the protection of information. These are the various sections that protect personal data under the Aadhaar Act. Then we have the RTI Act. आप सबने सुना होगा there is a conflict between RTI Act and the DPDP Act, right? आप किसको पता है कि Section 81J and the DPDP Act में थोड़ा बहुत conflict है, right? पता है आपको? Okay, दो लोगों को, 3, 4, 5, okay. तो I'll not touch that part because it is conflict, और वो हमारे अटॉर्नी जनरल के पास मिनिस्ट्री ने उनको दिया था कि टू डील विद इट. तो अटॉर्नी जनरल ने बोला देयर इज़ नो कॉन्फ्लिक्ट एंड द DPDP विल प्रिवेल एंड देयर इज़ नो कॉन्फ्लिक्ट बिटवीन द DPDP एंड द RTI एक्ट. Then the various Supreme Court orders which protect personal data, the Information Technology SPDI rules 2011. Again, these rules were also protect only sensitive personal data. And the DPDP Act will replace SPDI rules also. Right now, currently, our personal data is being protected by the SPDI rules. and other credit information companies, RBI circulars, TRI Act, Telegraph Act. These all act, also protect personal data. These are sector specific acts. So DPDP Act, will not be read वो अलग से नहीं पढ़ा जाएगा एक्ट. It will be read along with the sector specific guidelines or sector specific acts. Like for financial sector, we have to read DPDP Act with the various guidelines of the RBI. Key elements of the approach. Basically, DPDP Act आया क्यों? To protect personal data while enabling its process, to not disrupt ongoing processing while making data fiduciaries accountable, to ensure ease of living and ease of doing business. Basically ये additional obligations के लिए नहीं आया कि organizations पे आप extra burden डाल दो to hamper their processing on which personal data they are processing. Only principles laid down while avoiding a prescriptive approach, intrusive regulations. इस एक्ट में सिर्फ principles हैं. कोई we don't talk about the technologies to use to protect personal data, or we don't talk about how to apply these provisions. These are just the principle based law, and to carry out the act in a manner which is digital by design. And the data protection board will be established under this act, will also be a digital in manner. These are the principle of the act, and not only of the DPDP Act, but these are the principle on which the data privacy laws all over the globe are made on these principle only. अगर आप GDPR देखेंगे, PIPEDA देखेंगे, HIPAA देखेंगे, all privacy laws governed by these principles only. और आप जो भी provisions देखेंगे किसी भी laws में, वो सारे कहीं ना कहीं इन्हीं principle से derive होंगे. Like lawful and fair use, the organization can only process personal data for the lawful use and in a fairly manner. Purpose limitation, only they can process personal data only for the specified purpose which they have stated while they are collecting the personal data, or while they are taking consent of you. Data minimization, only store the data which is required. Do not store extra data which is not required for the specified purpose. Data accuracy, this is also obligation to maintain personal data throughout the life cycle, accurate and corrected. Storage limitation, you cannot store personal data beyond the time or beyond the specific purpose has been fulfilled, or if it is required by law to store personal data beyond the specified purpose. Reasonable security safeguards, we have to implement the reasonable security safeguards. We'll see what are these safeguards, and the accountability. The organizations is accountable for all above principles. The structure of the DPDP Act, we have 44 sections, 9 chapters, 1 schedule. बहुत easy to understand law है. कोई भी normal बंदा भी इसे पढ़ सकता है. ऐसा नहीं है कि law है. It's a law to it. You required lawyer to understand this law. It is written in a very simple language. We have obligations of data fiduciary. We give rights and duties, special provisions, data protection boards, and power function and procedure to be followed by board. Penalties and adjudications, and breach of provisions. क्या breach है, उनकी penalties क्या हैं? These are the structure of this act, and these are the rules to be read with the DPDP Act. We have 22 rules which govern this act, and these rules tells us that how to implement the provisions of the act. They're the scheduled summary of the rules. So let's start with the DPDP Act. These are the basic definitions under the Act. Personal data, you all must be aware of what is a personal data. Any personal data, any data through which an individual can be identified, can be termed as individual data. Data principal is any individual to whom the personal data relates, or we can say the data principals are the data owner. Data fiduciary is the entity who collects the personal data and determines the means and the purpose of processing data. And what does it mean by the means and processing? Data fiduciary decide करेगी कि personal data क्यों collect हो रहा है, what is the purpose of collecting is, and what is the means of processing. वो process कैसे होगा. अगर कोई entity ये decide कर रही है तो it will be the data fiduciary, and data processor is the entity who process the personal data on behalf of the data fiduciary and on the instructions of the data fiduciary. डेटा प्रोसेसर कभी ये डिसाइड नहीं करेगा कि अगर वो डेटा प्रोसेस कर रहा है तो वो कलेक्ट उसका पर्पस क्या है या वो कैसे प्रोसेस होना है. वो डेटा फिड्यूशरी ही डिसाइड करेगी, एंड दैट इज टेस्ट टू इस्टेब्लिश whether the an entity is the data processor or is the data fiduciary. Consent manager is a new concept which is not in any global privacy laws. It means a person registered with a board who acts as a single point of contact to enable a data principal to give, manage, review, and which keep the records of your consents. You can, if you are giving the your personal data to an data fiduciary through a consent manager, then the consent manager acts as a bridge between you and the organizations. आप उससे अपना डेटा कंसेंट डिलीट करवा सकते हो, कंसेंट का रिकॉर्ड्स ले सकते हो. प्रोसेसिंग, कोई भी एक्ट अगर आपके पर्सनल डेटा पे ऑपरेशन हो रहा है, इट इज़ टर्म्ड एज प्रोसेसिंग. चाहे वो डिलीशन हो, स्टोरेज हो, शेयरिंग हो, अमेंडिंग द डेटा हो, एडेप्टेशन, रिट्रीवल, अलाइनमेंट, इंडेक्सिंग, शेयरिंग, एनी type of act which is happening on data, it is data processing. Personal data breach, any unauthorized access to your personal data or the unauthorized processing to your personal data will be termed as a personal data breach. Now, कौन सी ऐसी organizations हैं जिन पे एक्ट एप्लीकेबल है? First of all, the name of the act is Digital Personal Data Act. So first of all, it only applicable on the personal data which is in a digital form, or if it is collected in a non-digital form, in a physical form, in a tangible form, and if it is subsequently digitized, then also this act applicable on those personal data. बट अगर किसी ने फिजिकली आपका पर्सनल डेटा लिया हुआ है और दे आर नॉट डिजिटाइजिंग दैम, वो स्कैन नहीं कर रहे हैं या वो उसको डिजिटल फॉर्मेट में कन्वर्ट नहीं कर रहे हैं, तो वो बिना कंसेंट के आपका पर्सनल डेटा ले सकते हैं. उस पर DPDP एक्ट एप्लीकेबल नहीं होगा. एंड इट also applicable to processing personal data if outside India. अगर कोई organization is based outside India and if they are collecting personal data of Indians and to offering goods and services to Indians, then also those organizations will be under the ambit of this act. And it is not applicable on a personal or a domestic purpose made publicly available by the data principal itself. If I am uploading my personal details or personal data voluntarily on any portal, then those personal data will not be protected by this act or made publicly available by law. If any government department or any department which is mandated by law to publish your personal details online, then those data will also not be governed by this act. And processing there is only one grounds of processing of personal data under this act, which is consent based. The organizations or data fiduciaries can only process your personal data after taking your consent, and there is no other lawful ground other than the consent, except there are certain legitimated uses which have been defined under this act. That these are there are 8 to 9 certain legitimated uses, and for those uses the consent is not required. Otherwise, for all the processing, for all the collection of personal data, we require the consent. And these are the requirements of the consent and the notice. Consent to be free, specific, informed. It should be unambiguous. Consent only with the notice specifying purpose. Consent only for data necessary for that purpose. And the customer or the citizen should have option to access the content of these notices, any of the 22 languages under the 8th schedule of the Constitution or English. And consent can be withdrawn at any time. And with the consent, the data fiduciaries are required to give the notice along with the consent. They can and notice should be a separate document. they should entail the itemized description of personal data to be collected, the service to be rendered. आप क्या क्या personal data collect कर रहे हैं. Consent के अलावा ये independent notice होना चाहिए. It should not be clubbed with the consent. ऐसा नहीं कि आप जब consent request ले रहे हैं तो आपने उसी में लिख दिया. There should be a proper notice that should be given to the customers or the citizens, which should have the itemized descriptions of the personal data. आप क्यों यूज़ कर रहे हैं, उसका पर्पस क्या है, इन्फॉर्म रिगार्डिंग राइट्स, एक्ट के अंदर क्या क्या राइट्स हैं, आप उस पर्सनल डेटा पे जो वो ऑर्गेनाइजेशंस कलेक्ट कर रहा है आप कौन कौन से राइट्स एक्सरसाइज कर सकते हैं, कैसे कर सकते हैं, कंसेंट विड्रॉ कैसे कर सकते हैं, कोई भी हाइपर लिंक या कॉन्टैक्ट डिटेल्स ऑफ द DPOs or the contact details of any person who is work on behalf of the data fiduciaries. It should be in clear, plain, understandable language. It should be archival. There should be record of these consent and notice. And these are the certain legitimated uses, like the state or the department of the state can use personal data for which you have already given consent. लाइक कोई राशन कार्ड बनवा रहा है, ठीक है, तो आपने ऑलरेडी सरकार को कंसेंट दे रखा है, तो वो उस पर्सनल डेटा के लिए अगर वो किसी और आपको बेनिफिट या सर्विसेज दे रहे हैं तो उनको दोबारा कंसेंट लेने की ज़रूरत नहीं है. दीज आर द एग्जेम्पशंस दैट द गवर्नमेंट सेव फॉर देमसेल्व्स ओनली. For the state to perform any functions under any law in the interest of sovereignty, integrity, security of India, for fulfilling any obligations under any law to disclose any information to state, to comply with judgment or order under law, to protect, assist or service during medical emergency for vital interest of the individuals. अगर कोई हॉस्पिटल में एडमिट है तो डॉक्टर उसका कंसेंट उसको रिक्वायर नहीं है कि वो पहले पेशेंट का कंसेंट ले, will be covered under the vital interest or in relation to the employment purposes. Employer can also in some cases process personal data of the employees without taking their consents. These are the obligations on the data fiduciaries, like to engage or involve a data processor only under a valid contract, and this is a very important obligations for the data fiduciaries कि अगर वो किसी डेटा प्रोसेसर्स की हेल्प ले रहे हैं कोई डेटा प्रोसेस करने के लिए तो दे शुड बी अ प्रॉपर वैलिड कॉन्ट्रैक्ट, बिकॉज अंडर दिस एक्ट डेटा प्रोसेसर्स आर नॉट लाइबल टू फाइन. द फाइन कैन ओनली बी इम्पोज ऑन डेटा फिड्यूशरीज. तो अगर आप डेटा फिड्यूशरीज अगर डेटा प्रोसेसर को हायर कर रहे हैं तो देयर शुड बी अ प्रॉपर कॉन्ट्रैक्ट जिसमें आप इंडेमनिटी क्लॉज डाल सकते हैं इन केस ऑफ ब्रीचेस फ्रॉम देयर साइड्स, दैट व्हाट कैन बी डन, हाउ टू इंडेमनिफाई. They have obligation to ensure completeness, accuracy, to implement technicals and organizational measures. They have to, there should be a reasonable security safeguards to prevent breaches, and the intimation of breach to data principal and the data protection boards. As soon as the data fiduciaries know about the data breach, they have the obligations to, notify of the breaches to the data principals as well as the data protection board. And this is unlike the GDPR where only under the certain circumstances the data fiduciaries are required to give the notification of breaches. But in the DPDP Act, whether the breach is small or a big, it doesn't matter. Any breaches you have to notify the data principals and the data protection boards. And there is obligation also that to the data protection board you have to notify the data protection board within the 72 hours after knowing of that breach. Whenever the specified purpose is are fulfilled, we have to erase data on withdrawal or consent, and ensure erasure of personal data by the data processors as well as whenever the any individuals request the data fiduciaries to delete their personal data or withdraw their consent, they have to ensure that the data processors are also deleting the personal data or also stop processing personal data which is taken on behalf of the consent. To publish the business contact information of a person's to answer queries by the data principals, it can be the data protection officer, and to establish effective grievance redressal systems, because the individuals can only go to the data protection board regarding their complaints regarding the processing of personal data after they have exhausted the option of complaining to the data fiduciaries. And for that, the data fiduciaries have to establish an effective grievance redressal system. और उसका कॉन्टेक्ट्स क्या होगा, उसका कॉन्टेक्ट डिटेल्स क्या होगी, ईमेल क्या होगी, हाउ टू complain them, any hyperlinks. They have to provide these details in the notice itself. So these are the reasonable security safeguards which the data fiduciaries has to undertake. Like they can use encryptions, obfuscations, or use a virtual tokens mapped to the personal data to protect personal data breaches. Appropriate measures to control access to computer resources. Measures to have visibility on accessing personal data through logs, monitoring, and review as to detect unauthorized access. Its investigations. So, if the data fiduciary is undertaking, these obligations, reasonable security safeguards, it will help the data protection board when any complaint comes to them and they investigate such matters. Measures for maintain logs for a period of 1 year, contract with the data processor for taking reasonable security safeguards, and whenever taking services of the data processor under the contract, you also have to put certain clauses regarding reasonable security safeguards. क्या data processor वही reasonable security safeguards अपने system में लगा रहा है या नहीं? This is a responsibility of the data fiduciaries to do due diligence regarding that. Appropriate technical and organizational measures to ensure effective observance of security safeguards. So there are two types of data fiduciaries under this act. One is the plain data fiduciaries and other is the significant data fiduciaries. Now, significant data fiduciaries are the classes of the data fiduciaries only which will be notified by the central government on the basis of the volume. कितना वॉल्यूम, कितना पर्सनल डेटा का वॉल्यूम है डेटा फिड्यूसरीज के पास, हाउ मच द पर्सनल डेटा इज सेंसिटिव, and the risk to data principle, potential impact and risk to electoral democracy, security of the state and the public order. So these are the factors which the central government will take in mind whether to put the certain data fiduciaries in a class of the significant data fiduciaries. And what is the difference? Significant data fiduciaries के ऊपर कुछ additional obligations हैं apart from what we have discussed already. Like they are mandated to appoint the data protection officers and the data auditors, and they have to do DPIA's data protection impact assessment yearly and the data audits yearly, and they have to give report of these assessments and the data audits to the data protection board every year. This DPDP Act also has the provisions regarding the children's personal data, like can only process personal data of our children after taking consent of their parents. No processing which is determined detrimental to the children's well-being. No processing that undertakes tracking, behavioral monitoring, or targeted advertisements. Although government may allow processing of notified purpose to enable use in case like a protection of abandoned children, and under the rules there are certain classes of the data fiduciaries like education institutions. They can process personal data of the children for certain purposes without taking their parents' consents. So, exercise of rights of the data principles. Data fiduciaries consent managers to publish hyperlinks, details of particulars required to enable data principals to exercise rights. So, there are generally 4 rights under this act. Right to access informations. We can straight away ask the data fiduciaries कि आपके पास मेरा क्या क्या पर्सनल डेटा है, आप किस पर्पस के लिए उसको यूज़ कर रहे हैं, to whom they are sharing, whether they are sharing with the data processors, आप कब तक स्टोर करके रखेंगे इस सिस्टम में मेरा डेटा. सो दीज ऑल टाइप्स ऑफ क्वेश्चंस नाउ कैन बी आस्क्ड टू द डेटा fiduciaries and they have to give answers to that. We can correct our personal data, we can request them to delete our personal data, we have to right to nominate in case of incapacity or a death. We can nominate any other persons to exercise these rights on behalf of me, and we have right to proper redressal systems. There are also duties of the data principals. Now in the DPDP Act सिर्फ data fiduciaries के ऊपर fine impose नहीं हो सकता. Data principals can also be levied fine by the data protection board. If the data protection board find that the data principals are in breach of these duties, These duties are to comply with the applicable laws while exercising rights, to not impersonate while providing data for specified purpose, to not suppress material information while providing data for any document or any services of the states, not to register false complaint with the data fiduciary or the board, and always furnish verifiably authentic informations. And these fines are the data protection board can levy fine up to 10,000 rupees on the data principles. There are certain exemptions for the government, like for central government and the notified agencies for security, integrity, and the friendly relations. They can, process personal data without taking consent, or for research, archiving, or statistical purpose, subject to standards. There are few exemptions for startups other than data fiduciaries, like requirement of notice, accuracy of personal data, storage limitation, providing right to access informations. Central government may exempt certain startups from these obligations. State exempted to correct erase if processing does not affect data principles. It is not mandated by the government. In all the cases they have to erase personal data whenever the individuals request them to. There are also other general obligations like for and rights of data principles are not applicable when processing of personal data for enforcing legal rights, for performing judicial functions, for investigation purposes, or in India the data of non-residents, or done for merger, demerger, to locate loan defaulters or his financial data. These purposes also the data fiduciaries are exempted. Data protection board to be established with the chairpersons and members. They can inquire into a data breaches and complaints and impose financial penalties, to give directions for remediating or mitigating data breach, may refer complaints for the alternate dispute resolutions, allow voluntary undertakings and penalize in case of breach of such undertaking. Data fiduciaries can also give voluntarily undertaking for any breaches the data protection board finds कि इस बार ये हुआ है, next time we'll take care, और नहीं होगा. And if the data fiduciaries first give the voluntary undertaking, and the data protection and the case again comes with the data protection board with the same fine, with the same issues, then no investigation will be holding, and किसी की सुनवाई नहीं होगी. They'll directly levy the fines of such breaches. To advise government to block the websites app at extra if found to repeatedly breach the provisions of the act. So the data protection board will work as a with the power of the civil court. They can voluntarily take the complaints. The board may impose monetary penalty based on the following factors. These are the factors like nature, gravity, type and nature of the data affected by breach, repetitive nature of the breach, realized gain or avoidance of loss, effort of mitigate such breach, likely impact of impositions of such penalties. So these are the penalties. The highest penalty is up to 250 crore rupees. Uh, this is for the breach in observing the obligations of the data fiduciaries to take reasonable security safeguards. If the data fiduciary is in breach uh, in observing the obligations to give the board or effective data principles some notification of the data breach, the penalty may extend to 200 crore rupees. And regarding the children, it may extend to 200 crore rupees. And it is not like that the highest penalty which can be levied onto the data fiduciary is 250 crore rupees. It can be clubbed if the data protection board finds that the data fiduciary is in breach of one or two provisions. Then the penalty of such provisions will be added. Other matters to be provided for the rules, like the conditions for registrations of the consent managers and its obligations, like consent कौन consent manager बन सकता है. First of all, the consent manager has to be registered with the data protection board, and they have to certain requirements for the consent managers, like there are the net worth should be of 150 crore rupees, and there are certain other obligations under the rules. There are also standards for exemptions for research, statisticals, and archival purposes. Appointments, digital. The board will functions totally as a digital on a digital platform. There will be a portal which will be established by the MITI. So this is the बेसिक अंडरस्टैंडिंग ऑफ द एक्ट के प्रोविजंस में डेटा फिड्यूशरीज के लिए क्या ऑब्लिगेशंस हैं, क्या राइट्स हैं, क्या ड्यूटीज़ हैं, क्या ब्रीचेस की क्या पेनल्टीज़ हैं. We are hoping कि इस month the rules will be finalized. This act is not enforced yet. It has been enacted, but it is not enforced yet. On the notifications of the rules, this act will be enforced, and there is also a time frame which will be given to the industries. We are hoping the industry will be given approximately 2 years to comply with this act. So it's not that कि एक्ट जैसे इन्फोर्स हो जाता है द बोर्ड विल स्टार्ट पेनलाइजिंग ऑल द डेटा फिड्यूशरीज. द टाइम विल बी गिवन टू द डेटा फिड्यूशरीज टू कंप्लाई विद दिस प्रोविजंस. Any questions? Yes, please.
Hi. Sorry, I joined a little bit late.
So,
One question you have mentioned, there are exemptions for startup. Just trying to understand what is classified as startup, and can you elaborate a little bit on the exemptions?
okay, so X just says that some startups can be exempted from such provisions, like giving notices to the data principals, or requiring consent for certain purposes, for reasonable security safeguards. So there are some provisions which from which the startups will be exempted, but वो स्टार्टअप्स कौन से होंगे, वो कौन सी इंडस्ट्रीज़ के स्टार्टअप्स होंगे, वो अभी गवर्नमेंट ने ऐसा कुछ भी डिस्क्लोज नहीं किया हुआ है. एंड दिस विल बी नोटिफाइड सब्सिक्वेंटली आफ्टर द रूल्स. जब क्योंकि अभी बहुत कुछ होना है. अभी डेटा फिड्यूशरीज आएंगी कि हमको सिग्निफिकेंट डेटा फिड्यूशरीज की क्लास में मत डालो. ऐसी बहुत सारी चीज़ होंगी कि कौन सिग्निफिकेंट डेटा फिड्यूशरीज बनेगा, कौन नहीं बनेगा. सो वी हैव टू सी दैट हाउ द central government will classify them, and also which startups they will take to exempt them. Abhi generally we don't have any factors on which the central government will decide. Welcome. Yes.
Question on the consent manager. Role of the consent manager will be initial consent देने के समय, or more as someone who aggregates the consents and helps the data principal to manage the consent. शुरुआत में ही आएगा या mid cycle?
So the role of the consent manager will be equals to the aggregator, which is working currently working in the finance sectors. So वो they are holding records of your consent throughout your personal data, and it is it is upon the individuals, it is upon me whether I have to give, when I'm giving consent to the data fiduciaries. It is solely my my options, my discretion, whether I have to give such personal data through the consent manager or just directly.
One more question.
Yes.
इंडिया में डेटा ब्रोकर्स का कंस्ट्रक्ट नहीं है जो यूएस में है, बट इंडिया में वी नो दैट डेटा डज एक्सचेंज हैंड्स, राइट, फॉर पेमेंट्स और नॉट. Does DPDP talk about that specifically as well?
Not currently, but we hope कि ऐसा कुछ बाद में आए.
So for being the consent manager, as you talked about, DPDP will decide who can be a consent manager. So to be the consent manager, what can be the specification that person required to be a consent manager? Who can aggregate the thing like a in financial ecosystem?
So there are various conditions which are given under the rules. Like if you say I can state you also all the rules from the rules also, but the basic उसमें ये है कि उसका total net worth कितना होना चाहिए. It yeah, company net. It should be registered as a companies under the Companies Act, and there are other obligations also that the consent manager has to fulfill before they have to register themselves with the data protection boards.
So for the registration process, these are the minimal things.
Yeah, these are the prerequisites.
After that, the application, on the basis of application, some will be selected as a consent manager, right?
Yeah, it totally depends on the data protection board कि वो आपको register कर रहा है या नहीं कर रहा है.
And what can be the cap of net worth, like high cap and low cap for the net worth?
It's It's around 150 crore rupees. Yeah. After the session, I'll also correct you. Yeah. Yes, sir. Please.
I have a very odd question. As a customer of a bank, after this act is notified, can I lock my data? Can I, except for risk and compliance, which is a regulatory requirement, can I lock my data? Can I prevent the bank to consume my data?
Sir, can you please also repeat?
Okay. So, I'm a normal customer of a bank. Yeah. I'm a customer of a bank. After this act is notified, except for risk and compliance, which could be from a regulatory standpoint or a law enforcement standpoint, except barring for that, can I lock my data and prevent the banks to consume my data?
So the act doesn't say specifically okay, you can lock your personal data. It just says that okay, you can stop the processing on behalf which is happening on behalf of your personal data, but it affects only you. That the if you withdraw the consent, the processing.
The banks don't take any consent from their customers while using the data. It doesn't happen. I have not seen this happening.
Yeah, you are right, sir. But sir, as for now, we don't have any such provisions that we can lock our data.
So, follow up on that. For the data which has already been taken, is there a reconsent requirement after DPDP comes in, becomes enforceable?
Yeah, basically, if the if the data fiduciaries have already taken your consent for the legacy data, they have to send the notice as yeah. So if you are already given the consent of your personal data, and on the enforcement of this act, the act obliges them to give notices to all the customers that why have you taken, and all the contents of the notice should be in the notice.
And so that will give an opportunity for reconsent.
Yeah. Yes.
Follow up on that, would providing the notices to legacy customers fulfill my obligation? And like as a data fiduciary, can I process the data, continually process the data, or should I go for reconsent from legacy customers to whom I have already supplied the privacy notice? Thank you.
So right now you are processing data. Have you already taken consent?
The consent is part of the bundle terms and conditions that I had already taken. So, as let's say if the rules are supposed to be in effect at a certain date, the customers that I have onboarded before that, I have to provide them a privacy notice. But then, do I have to go for reconsent as well, or should that
No,
privacy notice
reconsent is
suffice?
not required if you are giving the notice at the granular level and itemized descriptions of all the things which have been stated under the act. And the reconsent is not required. The notice will be fulfilled the purpose.
Thank you.
Thank you so much.